Hi everyone, good morning and welcome to today's webinar from CARB EPA Compliance for Wood Panel Products, What You Need to Know. Before we get started, I'd like to go over a few housekeeping items. This webinar is being recorded and we will send out the recording to you in the next day or two. You will also have the opportunity to submit text questions to today's presenters by typing your questions in the questions pane of the control panel that's located in the upper right corner of your screen. You may send in your questions at any time during the presentations, and we will address them during the Q&A session at the end of the presentation. So now I would like to introduce Nicole Muniz, Managing Director of SCS Global Services Environmental Certification Services Division, and Lynn Baker, Staff Air Pollution Specialist of the California Air Resources Board. Nicole?
Thanks, Janelle. You can go to the next slide.
Okay. Hold on a second.
Well, thank you everyone for attending today's webinar. Our intention today is to provide you the necessary information on what is needed for EPA certification if you already have CARB certification, and then also initiating new EPA certification, including labeling, exemptions, and compliance issues. Next slide. So formaldehyde has long been an important industrial chemical used in building manufacturing and also as an embalming agent. We all know the off-gassing of formaldehyde contains irritants to our nose and eyes. However, it is not until 1992 that it was identified as a toxic air contaminant by California Air Resources Board, and then later updated to and identified as a carcinogen in 2002. The building industry remained a significant source of formaldehyde emissions with the use of composite wood panels. So by 2007, the California Air Resources Board's final regulation for formaldehyde emissions in composite wood panels was approved, which we all know today as the ATCM 93120 regulation. Next slide. To put this into perspective, sensitivity for formaldehyde usually ranges above 0.01 ppm in concentration. Prior to 2009, typical workplaces had a range of 0.3 parts per million to 0.5 parts per million in formaldehyde concentration found. And then once CARB Phase 1 compliance was implemented in 2009, a steady decline in emissions in the workplace and beyond were found. And by Phase 2 implementation, emission limits were further lowering the formaldehyde concentrations in the workplace and school and residential residences. But also realizing that chronic long-term exposure to formaldehyde was a growing concern. Next slide. Consumers and public concern over the effects of formaldehyde only grew after Hurricane Katrina. This became a huge concern after the findings of the CDC indoor air quality testing of the manufactured homes between 2007 and 2008. The formaldehyde concentration limits that they found were 0.77 parts per million in concentration, where in normal levels in residents was found 0.01 to 0.02 parts per million. Next slide. Given these concerns, the federal agencies began to take notice, and by 2010, President Obama signed the formaldehyde standards into law. And furthering the work done already by the California Air Resources Board in implementing standards for formaldehyde regulation. And now as we move into ending 2017 and moving into 2018, we're now beginning the steps to finally implement the EPA regulations for formaldehyde regulations on a federal level. Next slide. So moving into EPA's TSCA Title VI compliance, it's important to understand the next steps for you as a manufacturer, importer, retailer, distributor, and where you can seek answers for all the regulatory requirements. Next slide. So to give a little bit of background on this, to start, the EPA had provided several webinars to both manufacturers, retailers, anyone that would be affected by the regulation, accreditation bodies, and certification bodies earlier in 2016 and throughout the year, and provided that because there were such differences within the CARB criteria for these entities, I want to start by recognizing that the steps that the EPA took. First, by recognizing and accreditation bodies and approving that by the EPA. And next, approving third-party certification bodies. These were also, as you see on the arrow here, reciprocal. Those approved by CARB already were approved interimly by the EPA. The next steps for the CBs will be to be accredited and approved by the approved ABs by accreditation bodies by the EPA. And the panel producers will be the next step in making sure that the implementation of the federal requirements are implemented. Next slide. In terms of product categories, nothing has changed in regards to the differences for CARB. EPA still recognizes the following product categories as requiring compliance for composite wood manufacturers, that being the hardwood plywood veneer cores, hardwood plywood composite core, particle board, MDF, and thin MDF. Next slide. So in transitioning from CARB to EPA, SCS does offer certifications for both these. We will maintain that through the end of the year and continuing offering both certifications and certificates to be in compliance with both CARB and EPA. CARB will recognize the EPA certification as it satisfies CARB compliance. To note, CARB will be maintaining its own regulation. We have been getting quite a lot of questions and inquiries in terms of if CARB will be phased out. CARB, and the reason Lynn Baker is here today is to dispel some of those notions and to understand the next steps for CARB and making sure that you maintain compliance with those regulations as well. Next slide. An example here is a certification by SCS and what all the requirements are in terms of for certification. Clearly noting that TSCA Title VI compliance for EPA is included on the certificate, the type of product category, the thickness of the product, and what it complies to, and in accordance with noting that what the mill number is, the special ID number for that, and our CARB TPC number. Next slide. To comply with labeling requirements for panel producers, SCS also creates lot label templates for sticker use on products. In this example, there's two examples for EPA compliance and CARB compliance. Each of the labels include the certified company's name, mill number, location, the unique lot ID that was used, production date, the material, and we'll also include our CARB TPC ID number. Next slide. The exemptions for EPA have not changed for CARB, from CARB. It is still available for ultra-low emitting formaldehyde and no added formaldehyde composite products. However, an exemption letter that is utilized for CARB for ULEF and NAF is not required by EPA. The TPC will, and provided by the regulation, is allowed to make the final decision for exemption. One thing to note, though, CARB is not unilaterally recognizing the same approval. So CARB will still require the exemption and executive letter for exemption for ULEF and NAF, and Lynn Baker will discuss that as well. Next slide. Enforcement. So key things to note for enforcement. As of September 25th this year, just a few weeks ago, EPA updated on their website enforcement and compliance updates. So as of then, compliance for emission standards, record keeping, labeling for suppliers, fabricators, distributors, and retailers. The original date for compliance was December 12, 2017. Please note that's been moved to December 12, 2018. The import certification compliance was moved from December 12, 2018 to March 22, 2019. And laminate product producers, their compliance date was moved from December 12, 2023 to March 22, 2024. And then conclusions of transition to CARB TPCs has moved from December 12, 2018 to March 22, 2019. So by that date, CARB TPCs must be an approved EPA by the approved EPA accreditation body. So it's a key thing to note in terms of ensuring that your TPC meets compliance. Enforcement will be similar as what we've seen with CARB in the past for EPA. Maintaining records, however, a minimum of 3 years must be maintained for all records for enforcement requirements instead of 2 years. Reviewing records, inspections, reports, and customs will all be used as a mixed compliance opportunity by the EPA. It's noted also that fines can go up to $13,500 per day per violation. So it's important to keep up to date with what's required and maintaining records for that minimum of 3 years. Next slide. So at this point, I'd like to kick it off to Lynn Baker to go over some updates for CARB on formaldehyde regulations.
Well, good morning or good afternoon, as may be the case for some of you. This is Lynn Baker with the California Air Resources Board. Nicole of SCS asked me to give an update on our formaldehyde regulation. So next slide, please. I'll talk a little bit about comparing our existing regulation with the new EPA regulation. I really want to focus on the differences regarding the labeling requirements, and then I'll give a brief update on where we are in enforcing our regulation and amendments that we're contemplating for our regulation. And then we'll both be open for questions at the end. Next slide. So as Nicole mentioned, California developed our regulation about a decade ago, and it took effect in January of 2009. As you know, EPA's regulation was finalized this last December, and they've postponed the compliance date from this coming December till December of 2018. We've heard a lot of questions, and I want to reemphasize what Nicole just mentioned, that California's air toxic control measure or regulation remains in effect, and we will continue to enforce our regulation in California. Next slide. There are many similarities between the state and federal regulation, but there are a few differences. The formaldehyde emission standards are identical, but there are some differences in the requirements. For the purposes of sales of products in California, if there's a difference between the California regulation and the US EPA regulation, whichever is most stringent is what will apply in California. Outside of California, of course, California has no authority, so only EPA's requirements will be needed to be followed. Some of the differences include there are some differences with regard to certification of panels. They're very minor differences. So essentially, if a producer is certified by a third-party certifier under ARB's program, they'll be certified under the EPA TSCA regulation. However, there's some minor differences in the testing requirements. And when Nicole mentioned that California may not accept the NAF or ULEF approvals by a third-party certifier, the reason for that is currently there are some differences in the testing requirements that EPA has in their regulation for NAF ULEF producers, that is, producers that are using no added formaldehyde or ultra-low emitting formaldehyde glues. There's some differences in those requirements from California's requirements, and those differences they're less stringent. So for California, we're working with EPA. We hope that they are going to issue some guidance to do away with those differences so that there will not be any differences, and then we won't have this issue. But right now, after December of 2018, if a third-party certifier approved of a NAF ULEF mill on their own that was not a ARB or a California-approved NAF or ULEF mill, we would want to certify them ourselves or approve of the mill ourselves because the testing requirements are more stringent here in California. And Nicole mentioned that the wood veneered laminated product requirements don't kick in until 2024. That's for fabricators that put a wood veneer on a composite wood product as part of making a finished good like a tabletop or a cabinet door. She mentioned the differences in the record keeping requirements, and then I want to talk now about the differences and similarities regarding the labeling requirements. So next slide. California and EPA require labeling of panels and finished goods. This slide just summarizes what the requirements are for labels on panels as well as finished goods. And I think most of you are already familiar with these requirements. Next slide. We have said before, and I want to reiterate, we will accept products labeled as being compliant with the EPA TSCA regulation for both panels and finished goods. We suggest that for finished goods, especially, that are going to be sold in California, that fabricators or retailers consider leaving the CARB label on the product and just adding the EPA label as an addition, because many retailers and consumers in California are very used to seeing that CARB Phase 2 label, and when they start seeing EPA TSCA and not the CARB Phase 2, until they become educated about this, a retailer might say, well, I don't want to buy this. It's not CARB Phase 2 compliant. So you may want to consider putting both, but if it only has the EPA TSCA label, we will accept it. Now, there is a difference with regard to small items. Finished goods that contain less than 144 square inches of composite wood material are exempt from EPA's labeling requirements. The composite wood material still is required to be compliant with the emission standards, but EPA does not require a label. California does not have an exemption for labeling of small items. So an example would be the picture frames that are in the photo in the lower right of this slide. Those would be small enough that they wouldn't need a label outside of California, but they'd still have to be labeled in California. Next slide. We will also, here in California, accept the statement of compliance on bills of lading or invoice that just says that the product is EPA TSCA compliant. I also want to emphasize that labels for finished goods should not include the third-party certifier number. We've encountered many times in the course of sending our inspectors out to retailers or distributors of finished goods, they have encountered labels that include the third-party certifier number on the finished good. That's not appropriate because it misleads retailers and consumers that the third-party certifier has verified the emissions of the finished good, which they haven't, because only panels are required to be third-party certified or verified. Next slide, please. Just a quick update on where we are in California with regard to enforcing our regulation. We have an enforcement staff that enforces all of our regulations across California. We have dedicated staff that have done inspections at panel retailers, distributors, and retailers of finished goods. They inspect products for compliance with labeling requirements. They look at documentation with regard to the statement of compliance that would be on an invoice or a bill of lading. We also collect samples. They will buy products. They'll buy cabinets or boxes of flooring, just as an example. And then we bring that material back to our laboratory and test the composite wood material in those items. To date, we've settled cases against 4 flooring companies for selling non-compliant flooring. The flooring was all labeled as being Phase 2 compliant, but the composite wood material in the flooring was far from being Phase 2 compliant. And then I just want to emphasize we have cases that are in various stages of investigation or settlement agreement, and we're continuing to enforce and investigate other businesses. Next slide. We had made the decision several years ago that we needed to make some amendments to our regulation, and we had a series of workshops back between 2011 and 2014, but on a parallel track, EPA was developing their regulation. EPA took many of our suggested amendments and included them in their regulation, but we want to make some amendments in the near future to clarify a few additional requirements and to align with the EPA regulation where appropriate. Our regulation most likely will not be identical in every place, such as the labeling for the small items. But we do want to align as much as we feel is appropriate. The goal being to improve clarity, improve enforceability of our regulation, and to ensure compliance of imported products. And before we would make any amendments, which we would have to take to our board, we will have public meetings and a public workshop, and the soonest that we would have a public workshop would probably be the second half of next year, possibly early 2019. And then most likely we would take any amendments to our board, hopefully in 2019. That's all I have. Thank you for your attention.
Okay, thank you, everyone. Nicole, did you have comments on just these additional services for SES?
Yes, just a quick note. These are our two main labels for cow compliance and the EPA TSCA Title VI compliance. Also to note that we are an approved IKEA approved third-party certifier as well.
Excellent.
That's all.
And great. So now, thank you, Nicole and Lynn. We have a few minutes for questions. You can still submit questions through the questions pane in your control panel. So I'll give everyone a few minutes to ask any remaining questions.
And then if any questions are thought of later, you can always email myself or Lynn. And our email addresses are on the last slide, which you'll all get.
Okay, we do have one question that just came in. If EPA or California enforcement were to find non-compliant board in a finished product that was labeled compliant, who is the enforcement action brought against?
I can answer that. This is Lynn. It would depend on the course of the investigation. So if we were to, for instance, find a cabinet at a home improvement store, such as a Lowe's or a Home Depot, if we found a cabinet that did not comply, we would try to trace that back. We would look as part of the investigation. We would see what precautions the retailer had taken to try to obtain compliant products. If they had no evidence that they had taken action to try to buy compliant products, for instance, if they hadn't informed if they have no documentation that shows that they've informed their suppliers that they need to have, for our purposes, CARB compliant products, or for EPA compliant products, if they have no evidence they've tried to get compliant products, and if they have nothing in terms of a statement of compliance from their supplier that indicates that they've received compliant products, they will certainly share in the responsibility. But if they do have that type of documentation, that would certainly lessen their responsibility, because at least they've made that attempt. But then we would try to trace it back. If the supplier of the cabinets was in the United States, we would try to take action against that supplier. Here in California, that would probably be within California. EPA could take action against any company within the U.S. If the cabinets are imported, then the action would be taken against the importer, whether that be the retailer, as it would be in some cases, or if it's a middleman, a distributor that's the importer that the retailer purchased from, then the action would be against the importer. Because I don't believe EPA can, but I know California cannot take action against a company in a foreign country.
Great, thanks, Lynn. Next question. How can a manufacturer verify compliance from a supplier?
Well, I can answer that as well. We suggest several things. We suggest that the question was, how can a manufacturer assure compliance from a supplier? So,
yes.
So I would interpret that to be a fabricator or a finished good manufacturer. So we would suggest that they contact their suppliers, ask them for records. How do you know that this is compliant? what steps has the supplier taken, if it's a distributor or importer, or if it's actually the mill that made the raw materials. Ask them for verification of that. We have examples of companies here in the U.S. that periodically send staff to their suppliers. So say they're importing cabinets made in Asia. They periodically send a staff person to their supplier in Asia to go to the cabinet maker, look at the products, see do they have EPA or ARB or CARB compliant raw materials that they are using to make those cabinets. They may also want to consider doing some testing of their own. None of this is required. It's all a business decision in terms of how thorough a company wants to be in doing checking.
Great. And a follow-up question to that, is there a database to look into suppliers?
We maintain a list of the certified panel manufacturers. So then that's another thing that actually I'm glad that came up. That's another thing that we suggest is that if the producer of a finished good asks his supplier, okay, well, where did you get this raw material from? Or if it's to try to trace the raw material back to the manufacturer, the panel manufacturer, where that manufacturer may be. We maintain a list of all the certified panel manufacturers around the world. If they say they bought it from XYZ mill in Vietnam, look up that mill on our database of certified mills. If they're not on that list, then that indicates they're not a certified mill.
And in addition, I'll add, Lynn, you can also look up the certificate on our SDS Green Products Guide. It's by company, or product line, and compliance. So those are avenues to just verify that the certificate that you're receiving for verification compliance is in fact current and on our database as well.
Right. One more question. As a fabricator, if our raw materials are CARB compliant, is it appropriate to label the finished goods as CARB and TSCA compliant?
That's what we would suggest, at least for sale in California. But I'm sorry, that was if the raw materials are CARB. I'm sorry, I didn't think through the question very well. You're saying if the products are CARB compliant, is it appropriate to label the finished good as being CARB and TSCA compliant? And the answer is no. Until the third-party certifier has been recognized by EPA and gives the panel manufacturer approval to label their products as being EPA TSCA compliant, only then can the finished good be labeled as both TSCA and CARB compliant.
Yes, and I'll add on to that too, that labeling for TSCA was not approved to start until August 25th. So you will start to see EPA compliant certificates available, but be sure to have that as on your records to verify that you have gone through the review to before you start labeling your final product.
Okay, we still have time for a few more questions. If all the proper compliance labels are in place, why should anyone be held responsible for a non-compliant finished good other than the manufacturer of the composite wood board?
I can answer that also. We have, under our state law, we have under our enforcement program for all of our products, we have something that allows us to take action against companies as being responsible, even if it appears that they've done everything right. Now, we will not take as harsh of action against a company that has all of the documentation that they've tried to get compliant products versus a company that has no documentation at all. There will be a very big difference in those two cases. But we do have authority under California law to take action. And it's not just composite wood, it's all regulations that we have. If the retailer or the distributor of a product had everything that they thought from the producer of the product, whether it be volatile organic content of paints or composite wood or sulfur content of fuel, if they had all the documentation, but then we do tests and conclude, no, this is out of spec or above the formaldehyde emission standards, we still have the ability to take action.
Great. Another question that came through, is the CPA an approved third-party certifier?
They are, yes. The Composite Panel Association is an ARB, a California Air Resource Board approved third-party certifier, and they have been recognized by US EPA.
Excellent. Any last-minute questions? We still have a little bit more time. But if not, again, the recording will be sent out to everyone in the next day or so. And if any questions come up after our presentation, feel free to reach out to Nicole or Lynn. Don't see anything else coming through. So thank you, everyone, for joining us today, and have a great rest of your day.
Thank you, everybody.